Hello friends, I am Advocate Kapil Tomar. Today I will discuss on the topic of lower judiciary. Friends, National Judicial Data Grid, it shows that 4.69 crore cases are pending only in district courts. It is a very large number. So when I ask from litigants or my clients, are they really getting the justice from the court? So they will reply, and in the same language they say, by God grace they will know they had to not come again in the court. People are scared to go to approach the court, even for getting the justice for their right. So friends, why? The main issue is come on the time. It is a very famous phrase: delaying justice, justice is denied. For one case, if we see in the civil cases, litigants spend 5 to 10 years to get the final decree, final judgment. And this issue never become in the political function or political election at the election. It never become the issue in the at the time of election. Instead of that, we know that judiciary is the pillar of the democracy. But now we see the data of the pendency of the cases. We know the basic reason that vacancy seat are vacant in the judiciary. But personally, what I have seen as an advocate in my practice, the procedural error, the procedural time taking, the procedure make the delay of the judge of the cases. Friends, most of the time of the court, especially the initial time of the court, morning time of the court, goes on the in administrative or clerical words. Judges first call the parties in the court for appearance, write the summons, write the fresh summons to defendants if defendant not appear. So these all are clerical works. Due to these clerical works, the judges have very less time to hearing judgments, hear arguments, evidence. There should be special court. There should be appointed lower judicial rank officer. She should be responsible for the all these clerical or administrative work. And then after doing that, he will assign the cases according to according to the senior judges. So there's it will help, definitely it will help. And another, we see that in if we see commercial court act, so pre-suit mediation is mandatory. To approach the commercial court, there should be mediation first, then the party can approach to the court to file the case. And if we see in the mutual divorce, parties are filing the mutual divorce, there is a 6 month cooling period. And it is the time taking, it make the burden on the judiciary, or make the it add the cases, pending cases. Already they are filing the mutual divorce, then why there's a need to 6 month cooling period. In one judgment 2017, Amandeep Kaur versus Harvin, uh, Amardeep Singh versus Harvin Kaur 2017, held that it is declaratory, cooling period is declaratory, not mandatory, but even if parties are living separately for 1 year, due to avoid the 6 month cooling period, party tell a lie or make a false petition on this. They said that they claim that they are living separately for 1 year. They avoid cooling period 6 months. So it is make the pendency of cases. And new rent court act, only parties can approach if they have registered lease, otherwise not. And we know that uh, small parties or small residents who are for the residential area, who are for accommodation residence property, they don't make registered lease, they just, it goes on the oral agreement. And they can, if there's any dispute, they can't approach to the rent court. They have, but they can go to the civil court or commercial court. So friends, it make again heavy burden on the courts, civil courts. Their registered leads is fine, but there should be file those cases which are not have registered leads. And CPC, if a partition, there is a partition suit, there is a two degree, preliminary degree and final degree. And preliminary degree decide the shares of the parties, that one will get that share and that one will get that share. And there, for the secondary degree, there is need to file the fresh application. And for filing the fresh application, it will take the 5 years again. It take the more time, it make the again time taking. In CPC order 21, it's execution, related to execution, and it has 106 rules. It is a wide order, and lots of the rules, it's make the confusing, and they just time taking a delay, make the delay to the case for the litigants. Friends, we need to do something more. CPC has been amended two times, 1976 and 2002, but still there's remain some points or some provisions which make the delay. So I have mentioned few points, and we need to do understand and make this issue as in the political, it should be make political issue, so that there should be reformed. So friends, thank you for watching this video. Have a nice day.